Hi, and welcome everyone. I'm Pam.
And I'm Briana.
This is the very first episode of Paralegals Unplugged, brought to you by Marvel.
So, in our podcast, we aim to break down all things legal into everyday language.
Having worked with a wide range of clients throughout our careers, one of the things, as most paralegals know, is that part of our job is to educate our clients.
You got it, Pam. So, when going through a legal journey, it can be a very overwhelming and stressful process. So, we're just here to try and explain some various terms and processes that you're going to be hearing and just kind of be there as a listening ear and a source of comfort.
Brianna and I both are career paralegals with a broad background in various areas of law, such as employment, civil lit, insurance defense, and uh, presently we're both in the family law space.
Yes. And out of all the areas that we've both worked in, we both find family law to be the most challenging yet most rewarding. It is a very emotional space, but we love helping clients kind of get to the other side of their legal journey.
So, what we hope is that our little podcast will help shed some light on the different terms and processes in the family law space, just to make it a little less daunting.
Yes, everyone knows that the legal world can be very overwhelming and very daunting. So we're just here to try and break it down and make it seem a little bit easier and a little bit more understanding than, it seems to be a little scary at first.
That seems to be a little bit scary.
So before we start getting really into it, I just want to give a quick disclaimer. So as Pam mentioned, we're paralegals, not attorneys, so we can't provide any direct legal advice. Nothing in this podcast is intended to infer or provide any legal advice to you. If you do need legal advice, we do advise that you consult with an attorney.
Thanks, Bree. Now, on with the show. What are we tackling today?
So today we're going to talk about terms that you might hear in a divorce proceeding. So we're not going to go through every aspect of a divorce today because we'd be here a very long time, but we're just going to kind of talk about the initial steps and just give a little brief overview.
Amazing. So, our first term of the day is going to be petition for dissolution. So, Bree, can you tell everybody what that means?
Yeah, so a petition for dissolution is also commonly known as a petition for divorce. You might also hear it depending on your state or your attorney. You might hear complaint for divorce or just complaint. So those all kind of mean a petition for divorce. So it's a legal document filed with the court by one spouse to initiate the process of ending a marriage.
So, given the fact that we're talking about different states and different jurisdictions, and they might be called different things, would you say that in the general sense, there are common threads of things that are gathered to start a petition?
Totally. I think, like you mentioned, every state is a little different depending on specific jurisdictions. Even by county, things can be super specific. But I think overall, the consensus is that, you're going to need a lot of the same information regardless of what state you're in.
So, what kind of information would that be? Like party identification, maybe requests for specific outcomes, things to do with child support or alimony, division of assets? Is that
You
the kind of thing you're talking about?
Totally. Yep. So just general identifications of the parties involved. So any information, if you hire an attorney to walk you through this process, you'll need to kind of give that information over to them. And then, same for the opposing party in the case. So everybody will kind of have to have a lot of info, self-identifying information. Like you'll probably have to send in your driver's license and provide addresses. And if you have children, you can go through, detailing child support requests and, information like that. Just the overall division of property and assets is the main thing in a divorce, and just also any other relevant matters that might come up for your specific situation.
Got it. Perfect. So, what is our first term of the day? Well, actually, this wouldn't be our first term. We just talked about petition. So it will
Second.
be our second term of the day. Uh, what are we going to talk about now?
So the first term, well, second term, like you said, that we'll cover is petitioner. So the petitioner is the party that initiates the divorce action. So if you're the one that's starting things off and kicking off your case, initiating an action, you would be the petitioner because you're petitioning the court and you're filing a petition. And that's kind of an easy way of thinking of it. Petitioner files the petition, and then a respondent files a response. So kind of the word itself is within the the case subject.
Got it. And then jurisdiction, we've talked about jurisdiction, which is another word that you'll hear a lot throughout your case. probably more so in the beginning. And it refers to the authority of the court to hear and decide a case. And it can be based on multiple factors, but most predominantly it's going to be about where the parties are located, or in some situations, if it's a custody situation, it's going to be typically where the kids are located. But that's for another podcast. Um, so understanding the jurisdiction is really crucial because it really does determine the court that has the power over your case. But that's not for you to worry about. If you have an attorney, they'll be able to help guide you through that.
Totally. So we'll move on from jurisdiction. We'll talk a little bit more about filing and service and kind of see what that looks like, because that is another, key step to your case and might be kind of a lengthy process.
So once the information you mentioned has been gathered and the petition has been drafted, it's time to file it with the court. And when it's filed with the court, that is what actually opens up the divorce case.
Yep. So that's kind of what we've been discussing, is kind of initiating that action. So once it's been filed, as you mentioned, we'll wait for the court to accept the document. And once it's formally accepted, it gets assigned a case number. So what you'll look out for from a client perspective to see if a document has been accepted would be like a file stamped copy. And depending on your state, it might be in the upper left-hand corner, upper right, depends. But normally there will be like a notification on the document that'll actually say the date and time that the document was formally filed and accepted with the court. Once that happens, you get a formal case number assigned. So it's, a variation of numbers and letters. That's like a personally identifiable case number to your specific case. And that'll be a resource for you to look up, any sort of upcoming court deadlines or dates coming up, or anything that was filed will be under that specific case number.
And then once the case has been accepted by the court, it gets the case number. The next step is to serve the other party. And that's called service process. And it is the legal procedure which party to the lawsuit notifies the other party that a legal action has been initiated. So can you talk a little bit more about that?
Sure. So service is a fundamental aspect of due process that ensures all parties involved in a legal dispute have an opportunity to be heard and present their case. So service of process informs the respondent. So if you're the petitioner, it would be the other party in your case, of the claims against them, and formally notifies them of their rights and obligations in the legal proceedings. So it gives them the opportunity to be served with all the documents. So they're notified by a personal process server. So an actual person, going to their address, physically handing them the documents, and then they have the opportunity to review everything, understand that, they've been served, and then take according, action necessary. So whether it's to respond in 20 days or 30 days, depending on the state. But that's kind of the next step there.
Got it. And service of process has to adhere to specific rules or requirements that are established by the court. And again, this is going to vary by jurisdiction. It can even vary, by county to county in specific states. So it's not like one size fits all. But there's some general rules around it. And then typically what happens is the process server is they're an official process server. Or they're a process server that has been appointed by the court, or it could be a sheriff that is going out and serving the other party.
Yeah. And like you said, that depends on, the state, but even more specifically, the county. So an attorney will be able to guide you through what's required in your specific state and county, and, take the best next steps for your case, just to make sure we keep everything moving forward as quickly as possible.
Okay, so once service of process is completed, the other party's been notified, they also have a certain time to respond. Like you mentioned, it could be 20 days, it could be 30 days, just depends on the jurisdiction that they're in. But in any situation, their failure to respond within that specific time frame, it might result in a default judgment being entered against them. Having an attorney is really helpful in situations like this because there are remedies that they can legally take to either compel the other party to respond, or they can file a default motion to basically just move the case forward from that point. But again, we're not attorneys, can't give you legal advice. It really depends on the jurisdiction, the state, etc. And your attorney will be able to walk you through that. But On the flip side, if you are the person that is being served with a divorce petition, that would make you the respondent. So you have to be really paying special close attention to the dates that you are responsible for responding by. So if you do get served, getting a hold of an attorney at the earliest convenience is going to be your best outcome, because then it gives them plenty of time to respond on your behalf, and you're not rushing at the last minute to try to respond.
Absolutely. Isn't that the truth? So, like Pam mentioned, working with an expert can help you avoid pitfalls and mistakes, and also any missed deadlines, and just make sure that, the goal for everybody is to just continue a case moving forward as quickly as possible. And the legal system and the courts can be a little slow. So, we want to make sure that we're calendaring dates and making sure that we're staying on top of any deadlines that are coming up on our end, just to, keep things moving as swimmingly as possible.
One of the things that we hear, like, what's going on with my case? And there's a lot of little pieces along the way that it might not seem like things are happening, but there are things happening in the background. So, like, once your attorney drafts your divorce and they file it with a court, some courts are super quick in accepting a case and assigning a case number. Others take a little bit longer. So there could be like a little pause there. And then service of process is another thing. It's really dependent on when the process server or the sheriff can connect with the other party. And sometimes that takes a few times. And typically in most states and jurisdictions, process servers have a certain number of attempts that they're required to make. So you have to be patient during that time frame, because somebody could be just they're hitting them at the wrong time, or they might be, evading service. But if that happens, don't worry. Like, if all of the attempts have been made, don't worry. There's other remedies. We can run skip traces to see if we can get a better address. We can do filing by publication. There's other remedies to being able to get that service taken care of so that your case can continue moving forward.
And like Pam mentioned, a lot of this can seem really stressful. And, like she said, if a process server has been making, many attempts, like let's say 4 attempts, and they still haven't served the other party in your case, we've seen all of this before. So although it's new and super stressful to you, we have the resources to kind of handle this and make sure that we remedy the situation and take the best next step, forward for you. So just don't panic. That's the, best advice we can give. We're here for you, and we'll talk you through, any questions and concerns that you have too.
Yeah, and be patient, and because it's not a one and done. It's a marathon, not a sprint, I guess is the best
Exactly.
way to say it.
Totally.
Yeah. So there's lots of little pieces to it. So like Brianna said in the very beginning, we're just touching on today, like how to initiate a divorce and what that kind of looks like. So we have another episode coming up, Brianna. What are we going to talk about in that episode?
So I'd love to tell you, but you'll have to tune in to next week's episode to find out. I love a good cliffhanger.
Uh,
So gotta
Can you
leave you on that.
can you give us a little hint?
Maybe. So yes, I will. So what we're going to do is we're going to take what we talked about today and just build on that. So we're going to discuss mandatory disclosures, marital debts and assets, and time permitted. We will touch on child custody and support. All of these will kind of build on what we talked about today, as I mentioned, and hopefully clear up, any questions or lingering terms that you're wondering about.
That sounds great. I'm looking forward to the conversation. So that's it for this week. Thanks so much for tuning in. Remember, navigating the legal system and all of its terms, it might seem complex, but with a little bit of explanation, it becomes a lot more manageable. And if you have a legal team, which I highly recommend that you do, you can lean on them. They're there to help guide you, and your paralegal especially is a really great resource, because your attorney's not always going to be available. They're in court, they're in hearings, they're doing attorney things, but your paralegal is very, very familiar with your case, and they can help answer like simple questions for you, and they can just be good listening ear, especially when things get stressful. That's one of the big parts of our job, and I think most paralegals would agree it's probably one of the most rewarding, is really being able to help our clients get through their journey. So
Absolutely. Totally. And even though we can't provide legal advice, like you said, we can give a great outline of what a typical case might look like, or what things kind of, the flow of things, how the flow of things work in the legal world, just to kind of set your mind at ease until we hear back from your attorney on, next steps or things like that, just to, keep the conversation flowing.
So just think of your paralegal as your little secret weapon that you have tucked back in your pocket.
Exactly. That's the goal.
All right, guys. Well, thanks for tuning in to the very first episode of Paralegals Unplugged, and we look forward to seeing you next week.
Bye, everyone.
Bye, everybody.